All right, let's move on to our holographic wills. So holographic wills are wills that are made in the testator's handwriting. And there's a lot of debate, not a lot of debate, there's a lot of different ways that different jurisdictions apply this. In California, what we say is that in order to be considered in the handwriting to qualify as a holographic will, both the signature and the material provisions of the will are in the testator's handwriting. So not everything has to be in the testator's handwriting, only the signature and the material provisions of the will are present. Now, we don't see a lot of holographic wills today, right? One that are fully in, but where we do see this kind of holographic will or something that fallen will is the idea of using a commercial printed form, right? So you go to Office Depot or you go on Amazon and you buy a will pack or an office supply store or what have you, and they give you a bunch of blanks and you have to fill in the blanks, okay? Those portions must be in the testator's handwriting, okay? So if, for example, let's say we had someone print out by the form, and they decided to use a typewriter to put in that portion. That no longer qualifies as a holographic will because the material provisions are not in the testator's handwriting. Okay, so that's where we could see that. Once again, not likely, not too many typewriters around nowadays, but if that were the case, then what would need to happen is then if it doesn't qualify as a holographic will, then we'll go back to see if it's an attested will. Okay, so as you can see, there's a couple of ways that we can have a valid will. Just because one is not attested, like we talked about, having all of the formality requirements of having two witnesses present, the testator sign and all that. If we don't have that, we may have a holographic will. Like I said, generally appears where we have a commercial printed form. And we do have a requirement of testamentary intent. That's actually true for not only holographic wills, it is true of attested wills as well. Generally not an issue when it comes to a attested will. It's usually quite evident of testamentary intent. But it is inferred when you have a commercial printed form will. So key point here is that if you come across a holographic will, if we come across something that may be a will and the parts of it are in handwriting, see if it may fit under a holographic will, maybe be valid as a holographic will under section 6111. Okay, material provisions of the will are in the testator's handwriting and the signature. Okay, now if it is not, let's say you say, hey, wait a minute, Rocky. What if there's a signature, but the material portions, or sorry, if the signed, but the material provisions are not in the testator's handwriting, or the reverse. Let's say the material provisions are there, but there's no signature. Well, what happens then? Then we fall back on the attestation requirements. Maybe it can qualify as an attested will with two witnesses, right? That's what would happen. So obviously, in an ideal situation, you would have a two witnesses signed who are present at the same time, and that the testator acknowledge a signature or the instrument to be his will. But as you can imagine, that's actually a pretty hefty requirement, to have all of those checkboxes. And, for those who are not either don't know or not well versed in the law, they may not know. They may just think, well, I just sign, and then I can have witnesses. I'll have my two children who are going to inherit under the will just sign off as my witnesses, and they don't unwittingly know that could cause issues as to the validity of that will. So maybe take a look at it, and it may be a holographic will. So these are different ways to take a look at will to ensure its validity under the probate code, so that it can be admitted to probate.